Good afternoon. Welcome to HUBZones webinar on the SBA's new Mentor Government-Wide Small Business Mentor-Protege program. We appreciate you joining us on this presentation regarding these new rules that so many government contractors have been waiting for the SBA to issue. Before we proceed with the webinar, I would like to first bring to our audience's attention the fact that you can go ahead and get the slides from our PowerPoint presentations. If you go to the Handouts tab on the GoToWebinar dashboard, that will allow you to download them and keep them and review them at your leisure down the road. Also, we are going to be making available a side-by-side comparison of the previous rules to the new rules. So those of you who are benefiting from this webinar and reviewing these slides can also do a comparison that's going to be much more detailed. We note that this webinar is going to be focusing just on the SBA's new government-wide Small Business Mentor-Protege program, not other regulations that the SBA also issued at the same time that these final rules were released. We just would not have time in an hour to deal with all those issues. We will be discussing them, though, a few of those final rules towards the tail end of this webinar, but for the most part, we are going to be focusing on the Small Business Mentor-Protege program. Before we proceed, just wanted to make sure that our audience was aware that even though we are attorneys here at HUBZones and provide guidance and counsel to our clients, for purposes of this webinar, this presentation is for informational purposes only, summarizes these rules that are fairly complex and are in the Code of Federal Register in many pages. So when it comes time for you to consider whether you want to mentor protege and or joint venture under these new rules, it is critical that you review the regulations carefully and you consult counsel. You should not be consulting these PowerPoint presentations and the comparison of the regulations as you move forward, because there is just added complexity to these rules that are not apparent to many contractors that may be thinking about pursuing opportunities under the new program or through joint ventures. Today, I, Tony Franco, and my colleague Katie Flood will be doing the presentation. I've been with the firm for over 25 years representing government contractors of all sizes, and Katie is one of my colleagues that has helped me over the years in helping our clients with protest, claims work, putting together joint ventures, mentor-protege arrangements, and just the wide array of consulting services we provide to our clients. The way we will be presenting is I will be starting with the first few presentations, and then Katie will take a number of the PowerPoint slides, and we'll be going back and forth. We hope to also take questions from the audience, although the focus of the presentation will be, for the most part, on making sure that you get this information that we have summarized in the PowerPoint. To the extent we are unable to answer all your questions, the questions during the course of this presentation, we will be following up afterwards to either individual questioners or as a group if we see that there's a number of questions that essentially seem to overlap, and we want the group to get the benefit of all the questions that others have been asking. With regard to our firm, before we move straight into the presentation, wanted to make sure you were aware of the fact that our firm is a government contracting law firm that is full service, represents clients of all sizes, and we help companies not only with their initial formation when they want to get into government contracting, but also once they've entered government contracting, how to participate in the different programs that exist where they may be able to leverage their status, or oftentimes we're representing companies that don't participate in those particular programs, but that do recognize the advantages they get from leveraging their positions with small businesses or 8A firms, service-disabled veteran small businesses, or women-owned small businesses. We try to keep the community informed of what is happening in the government contracting arena. We have a newsletter that we release, including blogs. We have weekly updates that we provide our clients. And for those of you who want to be keeping abreast of what is regularly happening in the government contracting field, we ask you to go to our webpage on a regular basis, or send us an email so we can add you to our newsletter. With regard to the presentation today, we are going to begin discussing the Small Business Mentor-Protege program, essentially what the rules say in terms of how this program is going to be rolled out, the mechanics of the program, what it takes to be eligible as a mentor and a protege, some of the compliance requirements, the application process, and then we're going to shift into all small business joint ventures because one of the reasons this program has received so much attention and the government contracting community views this as potentially very valuable to those who participate is the ability to joint venture with small businesses. And the SBA's new rules has codified for the small business programs how these joint ventures are supposed to be formed, not only in the context of small business set-asides, but also for WOSB set-asides and service-disabled veteran-owned small business set-asides. And then towards the end of the presentation, we're just going to talk about a couple other rules changes that we believe participants in the 8A program and small businesses should be aware of. Now, the new Mentor-Protege program that is now available to all small businesses. Moving right into what is at the heart of this webinar. This rule basically has been issued as a final rule to implement the 2010 Small Business Jobs Act, which was a law passed by Congress and signed by the President, which required that there be a Mentor-Protege program similar to that which exists for the 8A program for women-owned small businesses, HUBZone concerns, and service-disabled veteran-owned small businesses. Just before the SBA was about to issue a final rule implementing that program, Congress passed the National Defense Authorization Act of 2013, mandating that this program really be open to all small businesses. It led the SBA to halt the issuance of the rules that they were going to be implementing concerning Mentor-Protege program for these other groups so that they would have a Mentor-Protege program open to all small businesses. Approximately a year ago, the SBA, if not more, actually a little bit over a year ago, the SBA issued proposed rules on the Mentor-Protege program. The community submitted a significant number of comments. It took the SBA some time to issue the final rule, which is why everyone's been anxiously awaiting because of the benefits they saw that this program could have for companies that participate in it. The final rule was issued last month, and it's effective as of August 24th, 2016. So essentially, beginning tomorrow. Although, as you will see from or hear from our presentation, SBA is not accepting applications for that Mentor-Protege program yet. But to the extent small businesses are looking to joint venture and pursue opportunities that are going to be hitting the street after tomorrow, those joint ventures need to comply with these new rules. The SBA will be accepting applications starting October 1st, 2016, and it's going to be through an electronic application process. But in the meantime, though, those of you who are looking to joint venture, not with a mentor, obviously, if it's under one of this program, because until you've been approved as a mentor, you cannot joint venture if you're a large business. But for small business set-asides, there are going to be rules that the parties need to be mindful of if they're going to be submitting proposals between now and the time that firms are admitted into the program. Now, the new Mentor-Protege program is essentially codified in the SBA's regulations at 13 CFR 125.9, and it is patterned on the SBA's 8A Mentor-Protege program. It's what Congress mandated. They realized that 8A firms were receiving significant benefits by having large businesses as their mentors and joint venturing. So what the SBA has done here is basically created a program that looks very similar to the 8A program, although in creating this program, in order to make them as similar as possible, the SBA has also revised some of the 8A regulations for the Mentor-Protege and joint ventures because they realized that they didn't want discrepancies between the two programs. It's critical that companies that are thinking of participating in this program keep in mind that it is viewed as a business development tool. to provide companies that are participants with financial, technical, and management assistance. The SBA recognizes that there will also be contractual assistance that is provided by a mentor. However, the SBA does not look at the mentor-protege programs as a contracting program. It's a business development program, and we believe that's critical for companies that are thinking about participating in the program to keep in mind, because based upon our experience in the 8A world, the SBA had many issues when they were confronted with mentor-protege applications that highlighted the joint ventures and contracting work the two companies were seeking pursuing. So it's critical that as companies plan to move forward with this participation in this program, they really think through all the different kinds of business development tools that the protege needs and that the mentor can provide. Under this new program, all small businesses may participate provided they meet the eligibility criteria and the regulations. It's worth noting that mentors can own up to 40% interest in the protege. And one of the most significant benefits of the program is the fact that it creates an exception to affiliation, meaning that to the extent a mentor and a protege are working closely together on a procurement, the fact that they may be working in a way that would normally subject them to a finding of affiliation, to the extent the work that they're doing and the assistance that the mentor is providing is subject to the mentor-protege program, there should be no basis then for the SBA to find an affiliation between the two companies. Now, with regard to the most significant benefit of the program, also not only is it exception from affiliation, but it's the fact that a mentor and a protege may joint venture, and that joint venture would qualify as small for any federal government contract or subcontract where the protege qualifies as small for the size standard assigned to the contract. This also means, because of the way this program is going to work, that a service-disabled veteran-owned small business that has a mentor may now joint venture with that mentor to pursue an SDVO set-aside or a WOSD set-aside. To the extent that the protege needs monies to help capitalize it and pursue opportunities and or grow, the mentor can invest funds and own up to 40% of the protege. It's just one of the things parties need to be keeping in mind if you pursue a mentor-protege arrangement whereby the mentor is going to have equity in the protege is, what is going to be the exit strategy, assuming you want an exit strategy, once the mentor-protege relationship ends. Once a protege has essentially sold a 40% interest, once a protege has sold 40% to a mentor, but the relationship later ends, the mentor will still own that 40%. And so that does raise certain issues as to how the two companies will continue operating post-mentor-protege relationship. We note that the SBA has also made clear in the regulations that they would like agencies to provide incentives in the evaluation of contracts awarded to large businesses on full and open competitions where they may be providing their proteges with subcontracting work. One of the underlying reasons for this program is that the SBA has always wanted to have robust small businesses not only as prime contractors but also as subcontractors, so that the large businesses can rely on strong subcontractors that are small businesses to help them perform the contracts but also meet subcontracting goals. So companies that are participating in this program are going to be better positioned on full and open competitions if they are pursuing work with their proteges. Now, I will turn it over to my colleague Katie, who will explain the application process.
Thanks, Tony. We've already gotten a couple of questions about the application process, so hopefully we'll be able to cover that while we're discussing it right now. But as Tony mentioned, SBA has indicated that they'll begin accepting applications on October 1st of this year, so really just in almost a month. So when firms begin to apply, they're going to be submitting their applications to a new unit within the Office of Business and Development. And SBA kind of wrestled with how they were going to process these applications because they already have the 8A Business Development Office, which handles approval of 8A applications. So they decided to create this new unit within the Office of Business Development, and final decision authority regarding whether or not the mentor-protege relationship is approved is vested within the Associate Administrator of Business Development in the SBA. And SBA has also indicated that due to application volume, depending on how many applications it's, if there's an onslaught, they might institute an open-closed enrollment periods. That's something that I think they're tossing around. They're going to see practically how things work once things get rolling. The one office is going to handle all the applications for all the different set-asides, including the small business mentor-proteges, HUBZones, SDVO SBs, and WSBs. And again, this is something that they wrestled with, but they wanted to make sure, SBA wants to make sure that the new applications are handled in a consistent manner across all the various programs. The 8A mentor-protege program is going to remain separate and distinct from the new small business mentor-protege program. So the Office of Business Development will still continue to handle the 8A applications. And of note is that 8A firms, they can choose to apply through either office, either the 8A, continue with the 8A, within the 8A structure, or under the new small business mentor-protege program, depending upon which program they want to use. So application submission. We had a question earlier regarding whether SBA is going to provide a hard copy of the application or a sample application so you can see what you need to go through. That hasn't been provided yet. We haven't seen that yet, but SBA has provided a little bit of guidance. It seems that the applications will only be accepted electronically using the new online portal called certified.sba.gov. And WOSB firms might be familiar with certified.sba.gov because right now this is the portal for WOSB certifications, and this is where all the WOSB applications and verifying documents are uploaded. So this portal will be also operational to accept new mentor-protege applications starting October 1st. We've seen on SBA's website that applicants are required to register in SAM prior to creating a profile in certified.sba.gov. So that would apply to both mentors and proteges, that you have to have your SAM profiles up and operational prior to submission of your application. And then SBA also indicated that there's going to be an online training module that both the mentor and the protege will have to complete before they're allowed to submit their application. We haven't seen what that module is going to look like, and SBA hasn't provided any additional information about that, but that's just something that we've seen on SBA's guidance on their website. So getting into the specifics with regards to eligibility, both we're going to be covering what it takes to be eligible as a protege under the program and also a mentor. And as Tony mentioned before, that this program is modeled after the SBA's 8A mentor-protege program, so there's quite a bit of overlap from what we've seen before, but SBA also made some slight tweaks to the 8A rules that we're going to cover, and there's a few very minute little differences between the two programs, which we're also going to get into. So first, for both programs, SBA has said that the protege must be small under its primary NAICS code, or if it's seeking assistance and is under a secondary NAICS code, it must also be small under that secondary code. And this is a difference from the old rules governing the 8A program. Under the old rules, the 8A protege used to tie, the eligibility was tied to the 8A protege's program term. So they had to be within a specific part of their program term in order to qualify the program, or they had, or eligibility was tied to the number of 8A contracts they had received, or whether or not the 8A firm was small, under half the size standard of its primary NAICS code. So all those requirements have been done away with. Now SBA is only requiring that all proteges have to be small under either their primary NAICS code or under their secondary codes, which they're seeking the mentor-protege assistance. Firms are allowed to self-certify that they qualify as small for either their primary or secondary NAICS code. That's a difference from what SBA initially proposed, and SBA was going to initially require firms to, proteges to undergo size determinations prior to the application process. They decided that that was going to be too much work and too problematic, so you're allowed to self-certify that you're small under these codes. That's not to say, though, that SBA can't start, peeling back the onion once you start these application process and start to dive into your eligibility. If you're applying under your secondary NAICS code, for the small business program, the protege must demonstrate prior experience in a logical business progression that would allow them to seek development under that secondary code. So it's not an automatic thing if you're looking to apply under a secondary code. That's not a requirement for the 8A program. The 8A program, it seems like that you're going to need to be small under your primary code no matter what, because under the 8A program, if you're no longer small under your primary code, there's the SBA can begin to initiate early graduation procedures. So it seems like your small business size status under your primary code is a requirement for the 8A mentor-protege program, not so for the small business mentor-protege program. SBA, so generally, proteges are allowed to have one mentor at a time. SBA will approve a second mentor if the applicant can demonstrate that the second relationship pertains to an unrelated NAICS code and that the protege will be gaining some business development assistance that the first mentor doesn't already provide. And it's important to note here that if you are looking to participate in the program as a protege, you only get 2 shots. You can only be a protege under the new program twice, and that's it. There is no similar requirement for the number of times you can be a mentor, but in order to be a protege, you can only do that twice. SBA may also examine a protege's SDVOSB or WOSB self-certification as part of the application process, because those are 2 certifications that proteges are allowed to self-certify. So SBA hasn't already vetted, in many cases, the protege's self-certification, so SBA is giving themselves the opening to review those certifications as well. An additional requirement for protege eligibility is that the protege must also demonstrate how the business development assistance provided by the mentor will advance the goals and objectives set forth in its business plan. Business plan means something separate and distinct within the context of the 8A program, as that program requires offerors to complete an SBA Form 1010C, which is a fairly robust document. If you're a participant in the 8A program and familiar, that's a fairly robust document. It's unclear whether the small business program will require the small business proteges to complete an SBA Form 1010C, or if proteges will only need to include a statement of their business goals. That's unclear as of this point. So that's just something to note. So now quickly turning to mentor eligibility, there's also a few little minor changes here from the prior rules for the 8A program. Mentors must demonstrate that they are capable of fulfilling their obligations under the mentor-protege agreement. And this changes the old 8A standard, which required an affirmative demonstration of financial responsibility. I don't know if you've participated in the program prior, you might have noted that was the requirement. You had to demonstrate that you were financially a sound organization. That's no longer the case. Now it's only necessary to show that you can deliver the promised assistance under your mentor-protege agreement. However, it's the documentation that you submit to show that you can demonstrate, provide this assistance is fairly similar. It's pretty similar to what you had to submit earlier with regard to financial capability. It's copies of your tax returns, audited financial statements, or SEC filings if you're publicly traded. Mentors are also required to possess good character, demonstrate that they're not on the list of suspended or debarred concerned. They have to demonstrate that they'll impart value due to the lessons learned and their practical experience within their industries that the proteges will be getting assistance under. After approval, the mentor must annually certify as to its good character and favorable financial position. Only for-profit firms can be mentors under both the 8A and mentor-protege programs. It doesn't have to be a large business. The mentor can be any size, not just a large business. So if you are like a mid-sized business or another, a fairly large business under several NAICS codes but small under others, you can still participate in the program. Generally, SBA doesn't like to have mentors with more than one protege at any one time, but mentors are allowed to have up to 3 proteges concurrently if the mentor can demonstrate that there's no adverse impact on any protege. And interestingly, proteges can also concurrently serve as a mentor. They just have to demonstrate that the second mentor-protege relationship won't compete or conflict with their first relationship. And unlike the protege rules, like I mentioned last time, there's no limit on the number of times you can serve as a mentor. So remember, you can only be a protege twice over the life of your company. However, the limit for being a mentor is that you can only be a mentor concurrently with up to 3 proteges. But once one mentor-protege relationship ends, you can go on to another. We also want to quickly cover the requirements for the written agreement that the mentor-proteges need to enter. So the written agreement needs to tie to the protege's needs for management and technical assistance, loans and equity investments, cooperation on joint venture projects, and subcontractual relationships. So these are the types of assistance that the mentor can provide to the protege. There also needs to be a detailed description and timeline for the delivery of this assistance by the mentor, which will enable the protege to meet its goals. So you need to do a little bit more than just say, yes, we will provide back office support and we will provide bi-monthly meetings where we go over business goals. You actually need to list the number of hours that this will take for the mentor to implement such assistance and tie it specifically back to the needs of the protege, which again we were talking about a little bit earlier with regard to the business plan of the protege. We're not sure how much information you need to submit with that business plan, but you will need to the protege will need to provide some information with regard to its needs to the SBA. The agreement needs to have a minimum 1-year commitment. The mentor has to have a single point of contact with regard to managing and implementing the assistance outlined in the mentor-protege agreement. You have to identify any other mentor-protege relationships held by the protege, and this is for either another SBA mentor-protege relationship or an agency-level mentor-protege relationship. SBA wants you to disclose this information so it can review whether the assistance will be duplicative. And you can terminate one mentor-protege agreement, like for example, if you have a DOE mentor-protege relationship, you can terminate that relationship and apply for the SBA program, but you won't be able, and you can, but if you, SBA, once they review that agreement, they'll say, okay, you can use any and identify any assistance that you haven't used under your old relationship, but you won't be able to use the assistance that you've already capitalized on. So that's interesting. SBA is going to be monitoring what type of assistance you've gotten and how you can demonstrate that, and won't let you repeat the type of assistance that you've already gotten. So the written agreement must be approved by the Associate Administrator for Business Development. So that part of what they're there for is to make sure that the protege will be getting the assistance that's been identified. SBA has to approve all changes to the agreement. This is an interesting point. If control of the mentor changes, the relationship, the mentor-protege relationship, can continue if the mentor provides notice to SBA after the control change that it will continue to abide by the terms of the agreement. So you do need to notify SBA if the mentor changes control, either through a stock sale or asset acquisition, something along those lines. Either party may terminate the agreement with 30 days advance notice, and SBA will be able to review the agreement annually. And SBA also has the power to terminate the agreement at any time. For the participation period, each agreement will last up to 3 years. The agreement renews automatically. Once SBA reviews it on an annual basis, they'll automatically renew it. And the agreement will last up to 3 years for one agreement, and you can go up to 6 years overall for that one mentor-protege relationship. And as we mentioned before, each protege can have up to 2 3-year mentor-protege agreements with different mentors. So you can have the 2 mentor-protege relationships, and each of those agreements can be extended up to the 6-year period. So you think about it as 2 6-year relationships if you're going to maximize your protege participation. SBA also can transfer an 8A approved mentor-protege agreement to the new small business mentor-protege program after the company has graduated from the 8A program. So this changes the rules because, as you know, we mentioned before, 8A proteges prior weren't allowed to apply to the program in their last 6 months of their program term. They can now, and then just simply shift the relationship from the 8A program to the new small business mentor-protege program.
Thank you very much, Katie. Now turning to what happens to those firms that apply and have their applications denied. The SBA has recognized that companies can seek reconsideration of the denial of their mentor-protege relationship. That means that they need to file a request within 45 days of the date that that they received decision had been denied. The companies, when they submit a request for reconsideration, are able to provide additional information and documentation to address the SBA's issues with regard to why the application was denied. And the SBA can is supposed to issue a reconsideration decision within 45 days. In reviewing this regulation regarding the process for the decline of applications, what is unclear is whether the SBA, once you submit a mentor-protege application, is going to be engaging in a back and forth with the applicant to resolve issues that may arise during the application process or with the application and or agreement, or whether the SBA is frankly just going to receive the documents, make an assessment as to whether a firm is eligible, and then issue a declination letter which will identify all the problems. The fact that the SBA is allowing companies to basically submit additional information and documentation suggests to me that what they're planning on doing is very similar to what we've seen the SBA do with regard to 8A applications, which is that to the extent there is a back and forth with the firm, once they deny a company's admission to the 8A program, a company is allowed to basically repackage their everything. Now, that has been something that the SBA has done with regard to the 8A application process for years, that has strained their resources, and there's been only so much the SBA can do in terms of back and forth with the company that's applying for the program. Given the volume of applications that the SBA may be receiving for this mentor-protege program, it would not surprise me if the SBA is just unable to engage in a back and forth with applicants so that they can address the SBA's initial concerns. And it will be in the letter declining that a laundry list of items may be identified that a firm needs to address. Keeping in mind that the fact that you can revise everything, presumably the SBA is going to give you a very good roadmap of what the problems are. Interestingly, if the SBA denies the request for reconsideration, but there are new issues that are raised, you are able to request reconsideration again. But otherwise, you have to wait 60 days. So which isn't really that long a period of time to go ahead and wait to reapply. I would think that firms that are denied their admission to the mentor-protege program may though see certain issues that the SBA raises that are just so significant that you have to reconsider whether you want to move forward with that mentor-protege application. But that doesn't mean you should give up right away if you're dealing with just minor issues that need to be tweaked or revised to satisfy the SBA's concerns. With regard to evaluating the relationship, I think it's very critical for applicants to keep in mind that this program, it's a special program that's going to give participants a significant competitive advantage when competing with other companies that are not in the program. So as a result, since the SBA sees this as a tool that may be used by many companies just to go after contracts, and they want these mentors to provide all kinds of different assistance, it is critical that when you enter the program, you think very carefully as to what assistance you're going to be proposing to give to the protege, that the protege really consider what they really need, and that the parties need to be mindful of these reporting requirements that we have laid out here. That you need to identify all the technical and manager's assistance provided by the mentor, a subcontracts awarded, etc. Keep in mind too that even though one of the things that need to be reported here is whether there's been an equity investment by the mentor, I do not believe that a mentor can midstream through the first year of a mentor-protege relationship just invest in the protege and acquire equity, because that presumably could be viewed as a change in the terms of the original mentor-protege agreement, and you cannot change the terms of your mentor-protege agreement without the SBA's prior approval. So it's critical that as you are submitting the report that you keep in mind what you told the SBA you were going to do at the beginning, and that you haven't been doing things that fall outside what the SBA approved. But I do believe that it's going to be very important that the companies monitor on a regular basis what has been promised and what has been delivered, because the protege must provide significant reports in terms of what kind of assistance has been provided by category and hours. There's going to be an annual certification process for the protege, and these certifications really are designed to be able to force the companies to realize that should their certification be untruthful or misrepresent what's actually happened, that they can face significant penalties. And so it's just critical that companies realize that there will be a close monitoring of the companies, how they're participating in the program. And to the extent that firms are not really participating the way the SBA envisioned it, the SBA does recognize that the mentor should have a chance to explain why they perhaps haven't been able to provide the assistance. It may be that the SBA on its own identifies issues, or it may be the protege that brings to the SBA's attention the fact that the mentor promised certain things that they haven't delivered. The SBA has basically indicated that they will go ahead and terminate the MPA relationship if it's not working the way it's supposed to, and that the firm that is a mentor will be eligible to act as a mentor for a 2-year period thereafter. And the SBA has also indicated they're going to take even more draconian measures, such as requesting the procuring agencies no longer allow the mentor and the protege to continue doing work under joint ventures awarded because of the mentor-protege relationship. This is a rather extraordinary remedy, but we understand the SBA has done that in the 8A context. So there is a precedent, and the SBA is very concerned about any potential program of abuses. and to the extent that they would contemplate suspending and barring contractors that are taking advantage of the program and not using it the way it was intended. Now, one of the issues that has continued arising once this new rule was in the works is what happens to the other federal mentor-protege programs. Keeping in mind that there are a number of agencies or departments that have their own mentor-protege program, and the SBA has made very clear that the only mentor-protege program for small businesses should be the SBA's, unless the SBA's approved one for another agency. In recognition that there are a number of agencies out there that have their own programs, the SBA is giving them 1 year to basically seek the SBA's approval to continue those programs. This new rule, though, does not apply to the DoD's mentor-protege program, which is a program that was created by Congress back in the early 1990s, and because that's been essentially statutorily authorized, as opposed to these other programs that many agencies created on their own, that will not be impacted, or any mentor-protege program, the mentor-protege programs involving the Small Business Innovation Research Program or Small Business Technology Transfer Programs. Those will also not be affected. But to the extent there are firms here in our audience that are participating under these other mentor-protege programs, you should be mindful of the fact that they are going to be subject to an SBA approval process. And frankly, even if you're participating in those programs right now, that doesn't mean you can joint venture with your mentor, and it does not mean that you enjoy the same exemption from affiliation that applies under the current 8A mentor-protege program and the DoD mentor-protege program. Now, turning to the joint venture, since that is going to be such a critical component of firms that participate in the MP program, we want to make sure our audience is aware of the new joint venture rules that are going to be going into effect starting tomorrow. Katie?
Thanks, Tony. So as Tony said earlier, one of the main benefits of the new mentor-protege program is that the mentor and the protege can enter into a joint venture and compete for small business set-asides. So to go along with that main benefit, these new regulations now include specific joint venture requirements for small business joint ventures, including
SDVO joint ventures and WOSB JVs.
Right, exactly. So these requirements are mirrored in the individual program regulations of the other socioeconomic set-aside programs, such as the HUBZone, SDOVSB, and WOSB programs. Those joint venture regulations contain specific requirements for those individual programs as well, but we're going to focus mainly on the small business joint venture regulations that were created under this new regulation. But it makes sense if you're going to enter into a WOSB joint venture, SDVOSB, HUBZone joint venture, that you check those specific program regulations for any specific and special requirements for those programs, because they're in there. Trust us, they're in there. For joint ventures, though, the new regulations do provide this uniform requirements for all small business programs regarding the size and the content of the joint venture agreement. This is an important point, though. So this regulation deals with small business joint ventures under the new mentor-protege program mainly. So a joint venture between two small businesses targeting a regular small business set-aside under which each small business qualifies as small, they need not contain, that specific joint venture agreement need not contain any specific provisions or take on any specific form. So if you're just two regular small businesses and you want to enter into a regular small business joint venture, and each one of you are small under the size standard attached to that procurement, you're fine. You don't need to go through and make sure that you're ticking all these boxes. Just enter into a regular joint venture agreement. So the joint venture need not be incorporated or established as a separate LLC. SBA is now going to require a separate written agreement of the arrangement and delineation of all the responsibilities of the various parties. And in these new rules, the SBA made what we think is a very welcome change from its prior position, which required the joint venturers to specify the responsibilities for furnishing equipment, facilities, and resources from each joint venture partner, even when it came down to IDIQ and multiple award contracts, which is a little bit hard to plan and forecast for, especially when you don't know the requirements exactly for orders that will be forthcoming under those requirements. So under the new rules, there's only a general requirement that you have to provide general descriptions necessary to the arrangement and responsibilities of the parties. So that's a positive change. The new rules also require agencies to consider the past performance of the JV partners when considering the past performance of a JV entity. This is a welcome change as well, because we've seen in the past that many RFPs would require the joint venture itself to have the requisite past performance history, which, as you know, many joint ventures are entered into specifically to pursue an individual contract, so that new joint venture would be new and not have any past performance history. So now the joint venture can rely on the past performance of each individual joint venturer, which is good. There's also some new certificate of compliance requirements that we're going to be discussing a little bit later. And just to reiterate, that there's always been the requirement that the joint ventures for 8A set-aside contracts have to be approved by SBA, but SBA is not requiring that it approve each and every joint venture that's been set up to pursue a small business set-aside, even under the new mentor-protege program. So it's only still 8A set-aside contracts where you have to have the joint venture prior approval from SBA. So there is a new requirement that the joint venture has to be separately identified in SAM. And the 8A firm, and as we said before, the 8A firms have to submit the joint venture agreement to SBA for prior approval, but this just has, the prior approval needs to come prior to contract award. So there's no requirement that you have to submit the JV for approval at the time of proposal submission. However, be forewarned for all joint ventures that it's important prior to submitting your proposal that you've fully formed the joint venture and that you've fully executed a compliant agreement with all your joint venture partners. Because as the last bullet point says, size protests are permitted, including for 8A joint ventures. And if your size is protested, because you're entering into these joint venture relationships under the regulatory requirements to get the exception from affiliation, if you're not entering into regulatorily compliant joint ventures, you won't have that exception from affiliation, and therefore you could be large under the size standard. So it's important that you make sure that you vet these joint ventures very carefully, these joint venture agreements very carefully prior to your proposal submission to ensure that you're hitting all the regulatory requirements and that if your size is protested, you won't be found large. The joint venture regulation also has a new performance of work requirement, which is separate and distinct from the limitations on subcontracting, but for the small business of a mentor-protege joint venture must now perform at least 40% of the work performed by the joint venture. And this is similar to the existing 8A mentor-protege rule, which always required that the 8A participant in the joint venture, the mentor-protege joint venture, perform at least 40% of the work performed by the joint venture. And it's important to note that this performance of work rule, which is what I'm going to be calling it, it also applies to any 8A, SDVOSB, WOSB, and HUBZone joint ventures formed even outside of the mentor-protege program. So for example, if you're a WOSB and you're entering into a WOSB joint venture where the WOSB is the 51% owner of the joint venture and you're targeting a WOSB set-aside, within that joint venture you've got to guarantee that the WOSB partner is performing at least 40% of the work performed by the joint venture. Another major change, very welcome, I think, is that HUBZone firms are now allowed to joint venture with non-HUBZone firms. So before it used to be that it had to be 2 HUBZone firms that would form together in the joint venture to pursue any HUBZone set aside. And now HUBZone firms are going to be treated the same as the other socioeconomic programs, and in that HUBZone participants are allowed to joint venture with non-HUBZone firms. And within that determination, SBA will not consider the employees of the mentor or the non-HUBZone participant when determining that company's, the joint venture's HUBZone eligibility. It'll be the HUBZone joint venturer's HUBZone eligibility that will be determinative. This is one of the main takeaways, I think, from this new rule. You know, we've gotten a lot of, maybe not pushback, but it has been very clear from SBA. With regard to the joint venture structure, when you form a formal separate legal entity, SBA will not accept populated joint ventures anymore. So the joint venture may not be populated with direct labor, but it can be populated with administrative employees. And just for those of you who are not aware, a populated joint venture is when the joint venture itself will have its own employees. An unpopulated joint venture is where each joint venturer contributes employees for contract performance. So SBA has said no more populated joint ventures. They only want unpopulated ones. But you can populate your joint venture with administrative employees doing back office type support. So this is important. After August 24th, tomorrow, proposals submitted by populated joint ventures will not be covered under the exception to affiliation. So if you have an existing joint venture, we've been recommending that you go through and you want to continue to use that existing joint venture for additional proposals that you're submitting after tomorrow. We recommend that you go through and make sure that that joint venture is compliant with all these new requirements. Otherwise, there's the chance that SBA is not going to find it to be compliant, and you won't get the exception from affiliation. So if you have a populated joint venture, you're going to need to unpopulate it very fast if you want to continue to propose for contracts under that joint venture. If there's an informal partnership created, SBA is going to assume that it's unpopulated. And joint venture partners, they will have to share profits commensurate with their ownership interest in the separate legal entity. And the rule regarding revenues, the attribution of revenues hasn't changed. So you still attribute the revenues of the joint venture commensurate with the portion of the work performed by each joint venture partner. Another controversial change in the new regulations that SBA kind of slipped in between the proposed rule and the final rule is that with regard to joint venture project managers, the project manager has to be an employee of the small business joint venture partner, and SBA put in a provision that says if the individual identified as the project manager is not an employee of the small business joint venture partner, they have to get a signed letter of commitment from that individual. However, if you're in a mentor-protege joint venture, you will not be able to get a letter of commitment from an employee of the mentor. And SBA has said that they put this rule in place because they think that if you're utilizing a project manager taken from the mentor, that as soon as the relationship or the project's over, that individual is going to go straight back to the mentor after performance, and the protege is not maintaining or receiving the real benefit of having that individual as part of their workforce, gaining the institutional knowledge, things like that. However, we kind of think that there's really no guarantee that the project manager will stay with the protege even if it's not employed previously by the mentor. This is a concern whenever the protege hires outside its existing workforce, and it's not unique to the mentor-protege relationship. So we're unsure why this rule is necessary, but it's in there. So this is something you need to be mindful of when you're scouting project managers. If you're in the mentor-protege relationship, don't hire from your or don't have that individual be identified from the mentor.
Okay, turning to the certificates of compliance, just want to let our audience know we only have a few more slides regarding the mentor-protege / joint venture rules, and then we're going to quickly shift over to some of the other new regulations that we just wanted to bring to your attention. We would like to complete on time, and we have received a number of questions from our audience. Many of these questions, though, we noticed were actually going to answer as we continue going on with our presentation. So I'm not sure if we're going to have time to answer any of these questions while we are on this webinar, but we will be following up with questions from our audience afterwards in the next week or two. But turning real quickly to certificates of compliance, it's critical for all companies that are going to be doing these joint ventures and pursuing this work under the mentor-protege program, particularly that they are mindful of the fact that prior to actually performing any of these contracts under the JVs, you have to provide a certification to the SBA and the contracting officer indicating that the JV will be compliant with the regulatory requirements and that the work will be performed in accordance with the way the joint venture agreement says. And we believe this is just another way for the SBA and procuring agencies to be able to pursue civil false claim type actions for companies that make the certification and don't later comply. So I think this highlights the importance for the SBA of companies that are telling the agency and contracting officers how they're going to do the work, that they are doing that work in accordance with what the joint venture says. And this is particularly critical because of the new subcontract limitation rules, as well as the regulations that are in play with regard to the percentage of work that the small business protege must perform. Keeping in mind that the regulations only say that the small business or hub zone WSB 8A must perform no less than 40% of the work, but there's no definition of 40% of the work. But if we go by the subcontract limitation rule, which basically now under the new rule that went into effect a few months ago, looks at the receipts received by the prime contractor, be it the joint venture or just an 8A firm or small business, we believe that the 40% rule will be applied the same way, meaning it'll be looking at the percentage of revenues received by the protege in the joint venture. Obviously, when we're dealing with two small businesses in a joint venture, it's not going to matter how it is that they're splitting the work because they're both going to be doing the work however they please without running afoul of any regulation. With regard to the other additional certificate of compliance requirements, the SBA has set forth that there has to be an annual submission of report detailing how the performance requirements are being met. So clearly, the SBA wants to see that the companies are meeting the subcontract limitation rules both as it pertains to subcontractors and as it pertains to the joint venture partner. And also, once the contract is completed, the small business partner has to submit a certification and a report to the CO and the SBA that has to be signed by both parties, explaining how it is that they met the performance of work requirement and that they complied with all the other JV requirements. So it is going to be critical that companies realize that even though there may be exigencies that result perhaps in the way a contract is performed, that they need to somehow figure out how it is that they're going to address, such as the project manager, if he's an employee of the 8A firm and all of a sudden has a heart attack and dies, you have to make sure you bring in an employee of the 8A firm or the small business or WSB to do that work. Any kind of temporary lapses in the strict interpretation of these regulations could have dire consequences. And I do recognize that there may be situations that are extraordinary where things have to be brought to the agency's attention and the SBA right away if a company believes that there may be a compliance issue. Transparency is critical under these programs, and particularly in this day and age. Keep in mind that firms that fail to basically follow these rules may be suspended and debarred, and that can have just a devastating impact on a company. Even if the debarment doesn't go through, a suspension can put you, basically out of business. Lastly, we wanted to make sure that with regard to the SAM registration, the SBA has made very clear that these joint ventures have to be registered on SAM. In our experience, most companies, when they form joint ventures, still register on SAM because the joint venture is treated by procuring agencies as a separate entity. But the SBA wants to make clear that all companies should be registering on SAM with a DUNS number and CAGE number. And I believe that's the case whether you're creating a formal or informal joint venture. Now, quickly turning to other important rule changes. we wanted to go ahead and bring to your attention a change regarding the 8A program rules. Katie?
Sure. So the applying to the 8A program, SBA has made a slight tweak to its standard for the social, for this regarding its review of your statement of your social disadvantage. SBA is now allowed to apply pressure to those statements. So if the applicant does not provide sufficient evidence that the adversity the applicant faced was not due to another alternative and legitimate reason. So SBA is basically going to allow alternative theories when they're reviewing your application, unless they've legitimate theories, unless you've not submitted sufficient evidence to support that. They are also going to eliminate the requirement that you provide a narrative statement for your claim of economic disadvantage, which makes sense because really it's just a numbers determination anyway to see whether or not that you've demonstrated that you meet the financial requirements. Also within the 8A program, SBA is going to independently review your participants' primary NAICS code. So that's if they feel like you're kind of migrating out of your primary NAICS code, that your revenues have shifted, they're going to independently begin that process of reviewing. And this has implications for tribally owned entities in particular because, as you know, tribally owned companies are only allowed to have one participant in the 8A program that under each specific NAICS code. So this has some implications for those companies. And really quickly, one important change is this requirement with regard to size recertification, which is a requirement that we've seen SBA really kind of hammer on lately. We've seen a lot of a shift towards requiring size recertifications in more and more instances. And this is just a requirement that's been put in place due to a few decisions made by SBA's Office of Hearings and Appeals. So SBA, where OHA basically said that recertification when an affiliate acquires another concern is not a requirement for contractors. And SBA, I think they didn't like that interpretation, so they changed it. They made clear in the final rule that firms are required to recertify when an affiliate of that firm acquires another concern. So acquisition by the affiliate may be deemed an acquisition by the concern in question.
And keep in mind with regard to these revisions that we've updated you on, separate and apart from mentor-protege and joint venture, there were others in the final rule. We just don't have time to cover them. We'd be happy to explain to those of our attendees individually if they want to reach out to us so we can go over those with them as well down the road. We also, as you know, provide webinars on a regular basis. And in fact, wanted to bring to your attention that we are going to have a live seminar regarding the new mentor-protege regulations. On September 14th, John Klein, the SBA's Associate General Counsel for Procurement Law, will be attending, and he was one of the architects of these new rules, and will be able to answer questions. We believe by then we'll have even many of our clients and friends that will be attending this at the Ritz-Carlton here in McLean, Virginia. That by then there will even be more questions as to these program rules are supposed to be implemented. We have seen, looking at the regulations, that there seem to be a couple of provisions that are inconsistent and don't make sense, so we believe there will be some technical amendments to the regulations, but the best person to ask those questions to will be Mr. Klein, and my partner Pam Mazza will be there too, as well as several of our colleagues here to answer your questions to the extent he's unable to, or just time permitting. You only have so much time to talk to John, Pam, or any one of us, so we'll have a group of our folks there to help you navigate these new rules. We want to thank you for joining us, and as we said earlier on, you can get these presentations off. You can go to our website, and if you have any follow-up questions, please don't hesitate to reach out to Katie and me. Thank you very much. Bye-bye.